into today's webinar. I would like to take this opportunity to introduce our moderator for today's webinar, Mr. James Shoemaker, Regional President at Castle Group.
Thank you, Eric, and good morning, everyone, and happy Thursday. Welcome to today's webinar, Phase 2 for Palm Beach County. What does that mean for my association? First, I'd like to introduce and thank our two panelists joining me today. We have Ms. Paula Mara, attorney and shareholder with Rosenbaum PLLC, and we have Mr. Matt Reedy, community insurance risk management specialist with Plastridge Insurance. That's a long business card title, Matt. Before we go into our session, I just wanted to make sure that you all know who Castle Group is. Castle Group is one of the largest privately held property management firms in the state of Florida. We specialize in providing management services to apartments, condominiums, HOAs in Florida, as well as recently Texas. And we partner with over 375 associations from 7 different offices in the state, including my offices in West Palm Beach. And we are now over 1,800 Castle teammates strong, helping our board members and our residents. So enough about me, and if I could, I'll just go to Paula and Matt. If you could just do a brief introduction for yourselves, and we'll start the session.
Great, thank you, James, and hello, everyone. Thank you for joining us. My name is Paula Mara. I'm with Rosenbaum PLLC. We're a full-service law firm focused generally on community association representation. I have practiced law in Florida since 2003, so 17 years. And expanding into my 18th year soon, representing community associations, condominium associations, homeowners associations, and a lot of country club background as well. We are a full service law firm, so we do practice litigation, everything except for criminal and family law.
All right, thanks everybody for joining us. I'm Matt Reedy with Plastridge Insurance. If you don't know, Plastridge, the longest standing privately held agency in South Florida, going back 101 years to 1919 when we were founded in Delray Beach. I am a community insurance risk management specialist. The designation for that is CIRMS, awarded through CAI, and that's the PCAM equivalent for an insurance. So that's the highest designation I can earn through CAI for our industry. As of today, we represent around 1,100 condos, HOAs, and co-ops in South Florida, and that's where I specialize exclusively.
Excellent. Well, thank you both, Paul and Matt. So we're going to get into this, and Paula, you're the lucky one that's going to be up next because, you know, as an association attorney, right, you get all the easy stuff, right? So, but you know, a lot of the questions come to us daily in the property management world, and it centers around the reopening plans as it relates to pools, right? So. A big question with our pools are there any changes to the current order for our respective association community pools? Do we still have to monitor them? Can we open them without any staff on site supervising? Can we reinstate some of the amenities that we once had, such as aerobic classes? And are there any limitations on the maximum number of owners who can be at the pool at any one time? So, you know, there's so many questions that revolve around the pool topic. So if you could maybe give some clarity on what the phase 2 reopening changes were and how that affects some of the questions that surround pools.
Right, and there's a lot of specifics with respect to pools, as you pointed out, and it is the main question that we have been receiving since the phase 2 reopening. Actually, it's the easiest answer that we can give as well, because there weren't a lot of changes with respect to moving from phase 1 into phase 2 with the pools. The main question that we received was with respect to, do we need to continue to sanitize? Do we need to continue to monitor? And to both of those questions, the answer is yes. There's not a lot that changed from phase 1 to phase 2 with respect to the pools. The social distancing also still applies. The aerobics question, yes, the association can now hold the aerobics courses, classes, so long as you're still maintaining that social distance. The monitoring of the pools, again, it's the same as it was a month ago. The association, thankfully, from the Palm Beach County Order number 5 to number 7, the monitoring was lessened, if you will, with respect to having a staff member there at the pool under order number 5, moving into order number 7, and then again, presently today under phase 2 reopening. The association is required to maintain some approach to confirm that individuals utilizing the pool are social distancing. If they're in the same family, this is where it makes it difficult, especially if you're a larger association. Being able to determine who's in the same family and who's not in the same family with respect to social distancing can be difficult for our larger associations. And there's certain procedures that your manager from Castle can even assist, different ideas that your manager might add to the ability to know who's who at the pool. But ultimately, the takeaway point is the associations are responsible to continue to assure or confirm that the social distancing and the other CDC guidelines are being maintained. The locker room status has not changed. Those are closed. The women's and men's restrooms need to be cleaned regularly. Those are the types of things, again, your manager will assist you with to make sure that you can document those particular procedures are taking place. Document that from time to time you're checking on the fact that the social distancing at the pool is being maintained.
Okay, and one of the things I know you talked about too was, you know, having an attendant, right, at the pool at all times. And I think the answer, right, is that you don't have to have somebody there full time, but you do have to have some procedure in place for some oversight that ensures the social distancing is being adhered to, correct?
Correct. So as a board of directors, you want to make sure that you have communicated this as a board, the procedures going to put in place. Confirm that with the manager or other staff. And if you are a self-managed property or you're just a volunteer board of directors, we encourage those types of communities to, even if you have committee members or volunteers that want to make sure that those are being done from time to time. Another question we get, James, is can I still maintain the limited pool hours? The answer is yes. I spoke to a client the other day. I said, but I want to make sure now that we have 2 violations because people are using it past the extent, you know, the shortened hours. I want to make sure I have minutes that reflect that the board actually adopted that particular rule with respect to those shortened hours. So all of these different things kind of filter down into the details when it comes to enforce those or when you have a violation issue.
Okay. No, that's great. So Matt, on your side, from the insurance perspective, the questions that we get, right, we talk about liability and risk, and that's your specialty, right? So what is, in your mind, what is the risk for reopening the pools and the amenities and some of these common areas now that we've got some clarity on how we can open them, how we can staff, how we can clean them? So from an insurance viewpoint, what is the risk of liability on that topic?
Yeah, well, the transition from phase 1 to phase 2, there's really, from an insurance standpoint, not much, really no change as far as the policies are concerned. So that's the first thing I'm thinking about, is there's nothing that's changed as far as in regards to policies as how something would play out regardless of what phase we're in. So the risk has been there. The risk is still there. Paul and I had a pretty good conversation the other day about causation. And, you know, when this first kicked off, I'd have clients calling and asking me, and okay, when do we have to close our pool down? I go, well, really should call your attorney for that. I can't make that determination for you. But for the love of God, don't be the last community in a 10-mile radius to close your pool, because if you're the only one that's open and somebody gets sick, you have a pretty good case that could be built against you. So as society's kind of opening up a little bit more and people are moving around and more communities are having their facilities open, what we're finding, or my hope would be that it would be harder for somebody to make that case. And again, this kind of dips into the legal with Paula, but harder for somebody to make the case that they got it exclusively at the community's pool or the fitness center or whatever may be open. But if we do have that claim and somebody can make the allegation, the problem is how is it covered if we have the allegation? And from a liability standpoint, most general liability policies have that communicable disease exclusion, so it's just outright excluded. Some policies don't, but the best advisement we were given by the underwriters and by the executive management of those companies is we will adjust the claim as on a case or a claim by claim basis and as per the conditions of the policy, which is a pretty gray way of saying we may be forced to in specific instances, but we're really not looking to cover that. So my recommendation from a true liability, and that's what would cover somebody for bodily injury alleging they got sick, I would continue to operate as if under the assumption that there were no insurance. It's for me, I'm pretty conservative. I'd rather be safe than sorry here. From a directors and officers standpoint, it's a little bit gray as well, because it could depend on what exactly the claim that's brought against the association may be. So a lot of clients have opted to purchase the legal defense policies that are a relatively new product. And, there's some pros and cons there, where if we do get sued and our liability doesn't pick it up and our directors and officers doesn't pick it up, that the legal defense is at least there to pay defense costs, but judgments, settlements, appeals, there are some things that aren't covered in those policies that are important for the client to understand as well. So it's not you buy that policy and you can do whatever you want from then on. You still need to be cautious. You still need to follow the CDC guidelines, because you can end up in a lot of trouble.
Okay, that's great, Matt. Thank you. On that topic, we also have discussions and topics with our respective association attorneys and insurance companies like Plastridge, but we talk about waivers to prevent the association from liability for usage of the common areas. And is there I know that there's new products and new policies coming as a result of COVID. Would a hold harmless waiver or some type of a waiver, does that help prevent liability? Is it recommended? Anything on that topic?
Waivers are great because they can at least be a deterrent from somebody filing suit. But if somebody wants to come after the association, a waiver is not going to stop them. Paula might want to comment on this, but what happens if they sign the waiver, but then the unit owner alleges that you didn't follow the CDC guidelines and that's what contributed to them getting sick? Now we're talking about negligence, which would invalidate the waiver, and now they can come after you. And again, we're back in the same boat where we were with the insurance of, how exactly or is this going to be covered?
Okay. So it's really, to your point is and I know, Paula, you can testament to this, like, we're going to be sued for opening, we're going to be sued for not opening. So really a waiver is not going to prevent anything, but it may help bolster or support the messaging that we have, right?
Right. And the word I like to describe it is a risk assumption agreement in the context of COVID specifically. And I wouldn't call a waiver in any other situation particularly a risk assumption agreement, but our risk assumption agreement that we provided to our clients with the counsel that here it is, but we're not promising you anything behind this as well. But as Matt mentioned, it can act as a deterrent, and it can substantiate whether it's 3 or 4 years down the road and someone has sued, they filed today, but you're finally getting to jury, 3, 4, or 5 years down the road. It substantiates the context of what we're living in today with respect to our community association facilities. And also when we even go to Publix, we're assuming when we walk out of the house in this pandemic, a risk that is going to be there when we leave or when we invite someone in to our home that has left the property or the home. So when you do use the pool, when you choose to allow your child now under phase 2 to use the playground equipment, you are assuming a certain risk with that cannot be controlled necessarily by cleaning, by anything else. So our risk assumption agreement provides for those details. You want to make sure if you do have a risk assumption agreement, I just want to point this out, and you're asked, you're waiving a risk for a minor child. I've seen this a few times, not from our firm, but from other firms. There's an actual bold type print that needs to be in that risk assumption or waiver of liability for a minor, and it needs to be in a different font size. So keep that in mind if you've received a product that doesn't have that for a minor waiver.
Okay.
But ultimately, yes, it can act as a deterrent. It's not going to be the end all be all. Matt and I always like this conversation because in tort law, you have to have causation. I do believe that it's going to be difficult for a personal injury attorney to nexus that causation from the use of a facility. However, as we all know, it will be tried.
Right.
Who knows when it's going to happen? I haven't seen anything yet. But we'll see.
Okay. Well, I think, you had touched upon a few things, Paula, as it related to, opening up the amenities. And I think that a lot of the focus with our property managers and our boards and the owners is the fitness center and the gym. And I know at my community, they just opened up the fitness center to, partial use, and they have a scheduling mechanism. And I think some of the questions that our owners and our participants here on the webinar still like to know clarity on is, does it need to be supervised or not? And, how do you, mask or not, reinstating certain classes or not? Locker rooms, I think we're pretty clear, like, you can open up bathrooms, but they have to be intervally clean. So what is maybe some of the guidance that you can then provide to us just in terms of the incremental phase 2 reopening plan as it relates to gyms and fitness centers?
With respect to gyms and fitness centers, it's going to be fact specific, which is what makes your job hard and sometimes my job hard with respect to answering those specifics. But generally, with that said, the size of your fitness center is going to determine whether or not and how many people can social distance while using the equipment. Some of our clients have very large fitness centers, others have quite small fitness centers. So as a board, you want to look at that detail. Can you social distance in your fitness center? How are you maintaining, again, the cleaning and the hygiene with the use of the equipment? The answer to your question with respect to, does it have to be supervised? The answer is no, but again, it needs to be monitored so that the association understands and maintains the CDC guidelines are being respected by the users of that fitness center. With respect to masks, our recommendation is to follow the recommendations with respect to restaurants, where you are masked in between the use of a piece of equipment, but I don't think the association should expect or require a rule, and this is going to go into potentially, personal injury or tort. Requiring someone to mask while using the treadmill is probably not the wisest rule to promulgate. But, and again, if you're social distancing on that treadmill, then the mask can come off and probably should come off. But movement between the equipment, the association should promulgate that particular rule, or at least put in the minutes that that's what's going to be required for the gym.
Okay. All right, perfect. And it probably leads into another topic, Paula, with regards to the playgrounds and the tennis courts. And, I know there's a lot of conversations where it says, well, look, if I'm playing tennis with someone else, we're 50 feet and we can change sides on the other sides. And, there's some complexities to that, but can you speak a little bit to the reopening of playgrounds and other various recreational facilities that maybe don't have supervision, and how we monitor it, how we might want to clean those amenities when they're in use and open or not, and even things like signage. What's the proper signage we must have, which is that you pointed out earlier, which was use at your own risk. So what's some context around those types of things as it relates to playgrounds and recreational facilities?
I think I want to start out with just recognizing that many of the questions that we receive from board members who call, and frankly, they have a lot of angst regarding this decision because they are pushed one way and pulled another way. They have the individual owners who want these facilities reopened, and then they have the individual owners who don't want them reopened because there's risk associated with it. And then you have the board of directors themselves who have to make their own personal opinion, so to speak, with respect to whether to reopen or not reopen. And again, specific to playgrounds kind of points out in my mind. Of course, we want to reopen them, but they are more difficult than potentially your gym, which is associated with your clubhouse, which maybe your on-site manager can monitor that. The playground may be physically located where someone has to get into a golf cart and continue to monitor that particular playground, and more difficult to clean and maintain those particular cleaning requirements according to the CDC guidelines. So for me, as counsel, I make sure that my clients understand, as a board, you do have the discretion not to reopen at this point in time some of those facilities. They may not be popular, but it can be reasonable because you can't maintain those CDC guidelines, especially with respect to the playgrounds, et cetera. If you can, and you can regulate and you can document that you're doing what you need to do as an association to meet those guidelines, then you can reopen them. But if you feel like there's some hesitation or some problems with reopening, then it is a board discretion to continue to close those even during the phase 2 reopening.
Okay. And what about, Paula, as it relates to Clubhouse and those facilities? So, sometimes there's questions that come in with our social events. And I know, for Castle speaking, we have a lot of 55 plus communities. We have very heavily amenitized events and venues and social activities. And so, doing the social events, the ability for owners to even rent or just do it in terms of normal business, capacity size and limitations, and how we ensure that that our residents and our owners are following the rules, whether staff is on site or not. But I know that there's a big component of resuming social events that we're dying to do, right? Because we're all stuck inside our homes, and so how do we get back to the bridge, the mahjong, the bingos, et cetera, in a safe and reasonable way?
Such a tough question because, again, and there's no right or wrong answer with respect to this. I don't believe the association wants to put itself in a situation talking about incremental phase 2 reopening. It's a 50, less than 50 now recommendation with respect to social gatherings. And again, if social distance can be maintained, I believe that it would be difficult for a lot of our associations to open up to a degree that allows the clubhouse to be rented or used for social gatherings where, okay, we're going to keep it under 50 and we're all going to social distance. Factually, it's just difficult to do that. Can the association do that? The association can legally open up so long as there's not 50 or more. I had the question come up the other day where an individual member was frustrated because the board had opened the clubhouse and that particular person did not believe the association was practicing proper CDC guidelines with respect to social distancing. And can I call law enforcement? We've all heard stories in the news and relative to frat houses and frat parties, et cetera. So that comes into play as well. Can the association actually open itself up to being on the wrong side of the CDC recommendations? Are they recommendations? Are they regulations? They're recommendations under those Palm Beach County orders. So again, a difficult question because it's going to be a case-by-case basis, and it is up to the board at this point in time to determine, the pros and cons of entertaining the idea of having and resuming the card games at the association clubhouse. The answer would be yes, you can. Can you do it in a manner where, again, you have a practical approach, where you have scheduling, you have check-in and check-out times, and you also have someone available to make sure that that group has social distanced accordingly when they're playing the cards or the different games. But again, you're still touching the same cards.
Right. Okay. One of the questions that I get often is, we're dealing with our boards and we're trying to be proactive, right? And we're trying to predict what's going to happen, the what, the when, the how. And, in terms of how is Castle and how is our property management team, how are we working with our boards on the reopening of the amenities? And, as Matt stated, the phase 2 hasn't really changed a lot for us unless we had a restaurant component. But I think what we're doing is we're just making sure that we're being mindful of working with great attorneys and insurance firms like you, Paula, and you, Matt, but working in collaboration to talk about what you both have pointed out. We want to mitigate risk, right? And so providing guidance and thought leadership and best practices and what are other properties doing, that's where we can all come together and do a roundtable specific to the association's rules and regs, specific to the needs of the community and what types of amenities you have or don't have, and really come together with some strong basis for benchmarking, for lack of a better word. But I think that I've heard a variety of association attorneys say, look, it's not a matter of what they're going to litigate or sue upon. It's going to happen, right? That just happens whether you open the amenities for use and enjoyment, or that you close them, and if someone contracts, God forbid, COVID. So for us, we're really looking at making the best prudent decisions to manage the overall experience. And for us, we're always, as a management firm, we're saying, look, our job is to protect our team and our vendors and our owners' health. And so we're going to always err on the side of protecting health, period. I know it's an inconvenience, right, to not use something I pay for in terms of the gym or the other, or it's partial, but we really are focusing on that this is a very, very inconvenient distraction for the world, right? And in time, this will pass, hopefully soon. But for now, it's just going to be something where we don't get the things that we want, right? We weren't given this a fair shot at this COVID thing. So, having said that, we now look at how we can provide what's the proper staffing to fulfill the oversight of the amenities, right? So, what kind of staff do we use? What kind of scheduling are we using? Is it manual? They call in and they put it on the Excel. There's now systems and technology to do proper scheduling. The types of cleaning that we are going to do for the association and the types of sanitation equipment that we have on site and the supplies we have and what we use and the frequency that we use it. So supervision, cleaning, staffing, scheduling, a big thing is budgeting and cost, right? This is unfortunately an extra expense for all of our associations. And what we're ensuring we're doing is saying, look, let's have a separate budget line item that can track these expenses. And so at least we want to be able to say, this is what it was used for. Not that we have to defend it, but we want to be transparent and let our owners and our board know that this is a COVID related expense and here's where it's going and this is what it's going to be used for in the future. And then I think maybe a final part to really effective engagement with our boards and the community is communications, right? Like we always talk about at Castle, communicate early, communicate often, set good expectations, what's open now, what's not open, and the why. And, I think that I've seen a different style with different communities that we have where they'll do focus groups, they'll do surveys, right? It's trying to get an opinion. And I find that that's somewhat effective, but also find that it's tough because you may have 10% of the community that, wants something done and they're vocal about it, right? But the majority, did not want that. So I think communication and being transparent is the key at the end of this, provide good thought leadership. And I think, again, tying it all back, that collaboration between attorney and insurance and property management firm, that's where you feel that you're making the best business decisions, right? And I think another question that came in that I'll just speak to, it's really about how are we advising our managers on the reopening of these offices and the interactions for phase 2. And as I discussed, there's not a lot of changes really, but I think what we're trying to do is we're trying to look at adherence and enforcement, but doing that, like, as we say in a Royal Service way, like we're here to protect the association. So without COVID, we need adherence and adoption to the rules and regs. Now with COVID, we need to be a little bit more strict on it, and there's a good reason, right? It's our health. So those are the types of things that we're looking at. We can do a better job on the communications front where I talked about the surveys, but let's use the website more for communicating and setting expectations. E-blast, our postings, all of our signage, there's an expense to some of these things, but again, allowing the community to know that we're here to listen and to respond and react to those things and that we're being mindful of those needs, then I feel confident that we're doing our job. So, I think the big thing is some of our 55 plus communities, they do have restaurants. And so that change is where we saw a dramatic change, which is, we can have 100% occupancy, but it's outside, serving outside as opposed to inside. And I know nobody wants to eat right now outside in this heat, but really, other than that, not much has changed from a management perspective in terms of amenities and uses during this pandemic. So that's what I would say to that. And, Paula, maybe a tie into this is when we talk about cafes and restaurants, like I just alluded to,
Right.
What are the new rules and restrictions with regards to cafes and restaurants in associations? Are they different than, I'm going to go to Panera, I'm going to go to Ruth Chris, or whatever it may be? What are the emergency order restrictions and permissions, if you will, as it relates to cafes and restaurants inside the gates of the associations?
So I wouldn't characterize the community association restaurants differently than I would characterize a Ruth's Chris or anything like that. They're going to be 50% capacity inside at this point in time. Again, and that would be a decision of the board whether to be more restrictive than Palm Beach County Order number 15 or follow the order number 15 with respect to allowing that 50% capacity, of course, maintaining social distancing and partitioning in place between seating areas or parties. I believe there's also a limitation of 6 people. That would be interrelated people that come in together to be able to seat it together. But otherwise, those different parties need to be at least 6 feet apart with the partitioning and 50% capacity only for our restaurants, for the community associations. So
Okay.
not much has changed. Well, frankly, that is the big change, the 50% capacity with the appropriate partitioning for the restaurants. And again, I just want to kind of highlight that it still remains a board decision. And while we are under and remain in a state of emergency, just to point out, I have questions also where board members say, well, do I have to open this meeting? These are questions that occurred less frequently than they did 3 months ago, because we're now all into Zoom and we're all experts at Zoom, right? And we all know how to allow members to participate in the board meetings, et cetera. But I do want to highlight that boards should be recording in their minutes in an organized fashion the decisions that they're making and the reasons for making those particular decisions, just in case somebody decides to bring litigation with respect to the decision not to reopen something that could be reopened under phase 2.
Okay, very good. Thank you for that. And just to clarify, I don't know if I spoke correctly on this, but on restaurants, you can have full capacity and 100% occupancy to what the restaurants permit in an association outside. Is there a difference between the outside and the indoor seating?
There would be a difference on the outside with respect to the capacity. Again, you still have the social distancing requirement on the outside. There's no capacity requirement on the outside, except for, again, factually what your outside seating would provide for. But
Okay.
the interior is 50%.
Okay, got it. Thank you for that.
And again, keep in mind, we're wearing our mask as we walk in. When we sit down, we take our mask off.
Yep, understood. So Matt, what's the current trend right now on insurance renewals for our associations? And, I think we've always been mindful, right, with our boards about it happens, right? We have insurance increases and we plan for it. And this is whether it's property insurance or whether it's health insurance. And that's just a fact of life that we live in. But as it relates to COVID, what should we expect for our managers and for our boards and our owners in terms of what types of changes should we expect to see? Maybe whether that's the type of policy or on the pricing for the insurances.
Yeah, it's a great question. It's been an interesting 18 months since we started seeing rates really start to take off here. And, we had seen about a 5 to 7 year period where rates went down, and year over year I had 10% or more decreases for associations. And insurance is pretty cyclical, so now we're going the other way after the years for catastrophic losses of 2017, 2018, wildfires, hurricanes, natural disasters everywhere. So rates were already going up. So what I try to emphasize to clients is the increases we're seeing now are still far too early for COVID to really be the reason for it. Now, remember, again, we mentioned this at the beginning, where most insurance policies aren't expected to pay out for coronavirus, especially for associations in regards to liability. At best, we're skeptical that there could be coverage in most of these policies. So rate increases aren't coming from there. Outside of the association world, the big hit for the country has been the loss of business income for businesses out there that were forced to shutter their doors, restaurants who couldn't operate for months because the government said they couldn't open their doors and they couldn't serve anybody. And what we found is that the same exclusions for communicable disease, applied there, but that a pandemic did not apply to the loss of business income. So again, with Corona, we're not expecting most of these policies to pay out. Now, here's an interesting storyline that I've been following over the months is in particular states, there has been legislation introduced that has not yet passed that would require insurance companies to retroactively pay on the business income to insureds filing claims for loss of business income during all this. Now, the counter to that is there's some issues from a constitutional standpoint is how do you retroactively and legislatively enforce a party to pay out on a contract where it was specifically excluded. And that's, a big reason that we haven't seen this go forward, but nonetheless, there have been those efforts. And this is good timing because just this morning I was reading an article about how in Europe they were trying to legislatively enforce this. And a judge recently made a ruling that loss of business income would be covered in Europe for all of these businesses that were forced to shut down. Now, I have to do a little more research in this. I don't specialize in associations in Europe or businesses in Europe, but it seems that there is more favorable language in those policies in Europe that would allow the judgment to pass there and potentially not pass here. So the reason for going into this is if you have states threatening to force insurance companies to pay out on these claims, and the insurance companies are trying to get investors in so they can fund and so they can write policies and have everything behind them so they can issue the policies, is this scaring away investors and capital that would, we're seeing terrible increases right now, but is this scaring away investors that would put the additional capital into the market to stabilize what the rates are? And, a lot of this is just theory at this point, but it's been an interesting storyline for me to read because for me, this is probably the most direct influence on rates. And again, more theoretical than anything. But as far as rates go now, for months as well, I've been reading about different products they're trying to create from an insurance standpoint that would provide liability. And I haven't seen anything really come forward that's kind of our cure-all for everything, but there certainly will be products. I mean, look at perfect example would be cyber liability. 10 years ago, my clients would have laughed at me if I had told them to buy a cyber liability policy, but people started stealing funds from associations through computer fraud and funds transfer fraud and social engineering. And the market created the cyber policy because what they found was the crime policies didn't necessarily cover the social engineering. And it's not because they didn't want it to, it's just because nobody foresaw that that was going to be the issue. So a specialized policy came forward.
That's a great point. It's things are evolving and changing. And like you said, we look back at security and cyber threats, right? And be like, well, I've got Norton antivirus on my screen, right? It's a different world we live in. Guys, we have a variety of questions that are coming in, and some of the questions, it's hard for me to scroll through all of them, but we've got questions that have been coming in. I'm going to just take a peek here and see if there's anything that maybe I can throw out for all of us to answer or one of us so we can be attentive here. And some of these questions actually have been answered throughout the dialogue. So one of the things here is with regards to, Matt, I'm going to just keep it with you. So we talked about COVID having an effect on insurance premiums, but in terms of costs, the question that they have is there a percentage that we should be putting in as a plug for increases for next year to be safe? And then the question was other COVID-related insurance products to put a percentage of increase for. Is there a number that we could throw out as a guideline or not?
It's tough to say for everybody, just put 20% in there because it's unique to every association. If we're talking about a high rise on the water from 1970 versus, joisted masonry roofs, the wood frame roofs, 10 miles inland. I mean, it's brand new. There's just so many different factors that can go into it. I would say it's important to be aware of when your appraisal date is due for the condominiums in the room. Mm-hmm. HOAs, a lot of times we're updating those appraisals as well, but condos have the statute that requires it to be updated every 36 months, 3 years. So if you're due for that appraisal this year, not only should you be budgeting for that rate increase, but also accounting for that increase in the replacement cost values on the appraisal. We have seen those trending up, and those have been trending up for years. And the replacement cost values really haven't come down. I saw a big spike in it after Irma, because we had a few years where we had Harvey hit Texas, Irma hit Florida, the Caribbean got hit pretty bad, and so the cost of the availability of reconstruction supplies was low, which drove the cost of it all up and increased the replacement cost values when we were having those appraisals done. those appraisals done. So that's something to be mindful of. You know, I had a 10% increase last week, and I had another one last week that was closer to 30. So it just depends on the characteristics for each association. And, you know, for me as an agent, it's important for me to be showing my homework and showing the list of all of the companies that we're shopping the renewal out to. And, you know, we have access to everybody. So, you know, I call it showing my report card or showing my homework of this is what we had. And in a tightening and in a hardening marketplace, rates are going up, coverages are becoming less available, where if, you know, a couple of years ago, I did have a handful of 1% deductibles here in Tri-County. Now I think I'm down to 1, maybe 2 in total. If you were the 2%, you're starting to see insurance companies pushing you to a 3, and if you're with 3, pushing you to a 5. So the companies are pushing for the higher deductibles. They're getting the rate, and we're seeing insurance companies tightening in on their restrictions of exactly what they're looking for, where if it didn't fit perfectly in their box, you know, as recently as 3 years ago of exactly what they were looking for, sometimes they would take a swing at it anyways, because, you know, the reinsurance rates were so low for them. And that's the big driver for all of this, is the cost of the reinsurance for the companies. And June 1st and January 1st are the 2 big dates of the year where those contracts get renegotiated. And that from a global standpoint, it's been a terrible couple of years for losses.
Yeah, no, understood. One of the questions, Paula, has to do with regards to the election process. And I know that we've got a variety of means for, you know, the e-voting and get quorum. And there's a number of facilitators out there that help on the technology end with regards to the elections, because some of the clubhouses aren't open and some people do not want to come in the clubhouse, and they're going to do their board meetings and such from home or from remote. But one of the questions here was opening the clubhouse. There's a limit to the amount of people that can come, and residents are claiming that it might be not a proper election if we turned them away at the door. So can you speak at all about maybe the election nuances with regards to COVID and how things have changed, or maybe not, and some of the tools to help guidance on that?
Right. It's a great topic. And actually, I was just on a conference call, a status conference call with an arbitrator, where the other attorney was arguing that an election is impossible because of COVID, and therefore we can't have the election. And the arbitrator frankly kind of chuckled. So let's start with that. The election process with Zoom, with the reopening of 50 or less to your clubhouse, it is possible. So if you're a board that believes that you're going to continue to push off the election that should have happened in March or April, and we're still kind of having those elections now. I know Katie's been very busy with having 4 or 5 last month. So you do want to organize your election. How that looks is a completely different story, right? We can't have elections in the clubhouse now with social distancing. I have a particular association that has the line outside the door, so it's going to take a longer process. If the owner doesn't want to participate in the election in person at the clubhouse, then you also organize the ability to do that via Zoom. If you're a condo, it's actually easier than if you're an HOA and you have a proxy voting process where you're going to have to organize that. We've done 2 or 3 of those recently. So again, first takeaway point is COVID is not the reason to push off or continue not to have your election, your annual meeting of directors. And then second, yes, it can be done. It can be done also via Zoom. You're going to work with your attorney to make sure that you're maintaining the process accurately. There are going to be some margins where you can move into just because the election may be conducted via Zoom. And it really goes back down to the size of your association. When you have a really large association, it's going to be quite a process. But we can make that happen, and we've been doing it successfully via Zoom. And also now making sure that we're moving into some of our clients in Port St. Lucie and Martin County have been having their elections in their clubhouse. They've just been, again, maintaining social distancing and the other guidelines with respect to the CDC. So now that Palm Beach County is in that situation, there are ways and manners at which we can vote in person and have the annual election in person, coupled with, depending upon the size, the Zoom meeting at the same time.
Okay. So really the amount of people that can come or not into a clubhouse doesn't have weight or bearing on still being able to conduct business as normal, board meetings and elections, right? There are tools to help
Correct.
those things, which is your point. Okay.
Right, and I think it's helpful, again, when we were arguing with the opposing counsel in this arbitration status conference, where that was their angle. We can't have this election because of COVID. It's too dangerous. And the arbitrator in that situation, again, kind of chuckled, and we all kind of chuckled, because the argument was, in today's world with Zoom and all the other technology, yes, you can have your annual meeting, your election, and you just need to be cognizant of how you're going to actually carry that out.
Okay, very good. A question that came on the screen here, I can take. It's asking about, do castle property managers work from home due to COVID? And the answer is yes. And so what I can tell you all is that every property and every situation is situational. It's different, it's unique. And what we're trying to be mindful, and I will tell you, I'm so thankful and grateful to our respective boards, because they have been mindful and appreciative of what the personal needs are of the employee, right? So it's not just the property manager, but with regards to the question, we're looking at the considerations of what are their personal needs and issues. Do they have children or not? Are they doing brick and mortar school or not? Is it virtual school or not? Do they have daycare concerns? And so we're trying to really focus on what they're going through and how to help them be successful, while at the same time managing our day-to-day of what we're hired to do, right? That's our job. And so, yes, we're considered an essential service. And yes, most of our PMs are physically on site managing the day-to-day and working. But we do have several scenarios where their life and family situation changed, and we have empathy and sympathy for that. And so we've been able, though, to be very successful by staggering or helping or have flex hours, what have you, to manage the day-to-day and to cover that. So I think, it's a situational thing, but my specific, county perspective is we have a good amount of property managers that are flexing right now. So they are physically at the property and they're physically at home. And it's really coming up with a schedule that makes best sense for all involved. And the board agrees or not, and we talk through it and we make a plan, because we also have the ability to have other properties to help check in when they're not there. We have our regional directors, of course. So we're still looking at making sure we're meeting expectations on site or not. And so far it's been very effective. And so far we've had a great collaboration and partnership with those boards in that topic. Another question that just came in that I can look here. Paula, with regards, do you have any comments or insight as it relates to how we monitor things via a camera? So, when boards come to us and say, well, we need to monitor and oversee and have oversight at the pool or at the gym if they want to. If we don't have the people or the budget to do those types of things and the resources, can we use cameras to kind of monitor, whether it's live real time or going back and making sure if there was an issue, we could go back and say, well, they didn't do this correctly? Like, do you have an input on use of cameras?
I do. Yeah, I do. I think, the level of the supervision is what's important, whether it's done live or if it's sufficient and reasonable to monitor a camera, even if you're rolling back that tape and finding that group or this group has refused to maintain the social distancing, and then you go into, issue a violation or what have you. But I think cameras are sufficient. I think that if you're monitoring the camera either live and you're at a different location, that so long as you're meeting the requirement to confirm and maintain the CDC guidelines is sufficient. The camera would work just as well as someone actually, driving by in their golf cart or whatever other procedures that our associations are using right now.
Okay. Another comment, maybe this is a general comment. It's technical in nature, but it's an interesting one, and that's why I'm reading it right now. It says, please comment on air filter and airflow, determining opening of the gym and et cetera. So, it made me think about, like, we may have all the best protocols and supervision and awareness and signage, But if there is, COVID there, right? It's whether it's in the air or it's on the actual surface. Do you think that Matt, from your perspective, have you heard any issues on liability or issues in terms of the servicing of our air equipment and filters in our clubhouses as it relates to health?
That's a good question. It's a new one for me and
Yeah,
interesting to kind of think through. I guess the first records request would be how often were we changing those filters out, and is it 6 months old or do we change it every month?
Yeah, so the preventative maintenance schedule is probably the root of the issue, right?
Interesting. Yeah, it's about as far through as I can think it right now.
Yeah.
I have to put some real thought into that one.
Yeah. Well,
It's a good topic. Sorry, James, it's a good topic. I was just going to mention, I read just yesterday a study, whatever that means, right? When you read these on the online resources, a study that individuals that wear eyeglasses have a lesser risk of contracting COVID than those that don't. Whether that study is accurate or not, I don't know, but it's a great question and it's a great thought with respect to whether or not the association has a duty to even increase or purchase some of the products that have come out recently with respect to the air quality or air cleansing and air purifying. There's no duty at this point in time. So monitoring at least and maintaining those air filters would be the threshold.
Right. Okay. And there's a lot of questions that are coming in with regards to getting the updated guidelines from the CDC and getting specific information about the county specific. And so, we always refer people to go to the CDC Center for updated information. And so cdc.gov is the official site for the general CDC, right, in nature. But is there anything, Paula, that we should tell them, another great site to go to, whether it's palmbeachcounty.gov, or what are the other types of sites or links that we could refer to them to stay abreast of information?
What's difficult about the Palm Beach County orders is even as an attorney, sometimes they're difficult to get through. And they're also difficult to go from 5 to 7. Now we have 15 and blend that information together to determine what we do with our pool, what we do with our gym. My recommendation would be, and the site that I have found most helpful is the CDC site. And through that site, even the signage can be ordered and the different postings can be downloaded so that you can print those out and post those in your gym, post those at the pool. Again, kind of healthy reminders that we have them posted here in the office, in the bathroom, in the kitchen, where, basic stuff, wash your hands, cover your mouth, cover with sneeze, whatever it is. But I think it's helpful to show that the association is being responsible with respect to advising the association members of maintaining those CDC guidelines at those particular common facilities. Mm-hmm. And that CDC website, it can be a little bit difficult to move around in, but it does, in my opinion, have the most helpful information. Whereas when you Google Palm Beach County orders, you're going to pull up the orders from as early as February, the last week of February, all the way through even last week. And they are difficult to get through. We have an article that we presented, I believe last week, right, Katie, last week, that we have available to anyone who requests that from Katie. Additional law firms are putting out those particular articles as well. And I think that's a good place to find condensed information about what the association board should be and should not be doing with respect to the facilities.
Okay, good stuff. Guys, I think we could go until 5:30 tonight. There's certainly some great questions, and being respectful for everyone's time, including our participants. It's 11:29 and we have a hard stop at 11:30, but what I would say is for all the participants that have joined, we really want to thank you for attending, for listening. Want to thank you for all the questions that have come in. All of these questions we are going to tabulate and do our best to be responsive to you all on the specific questions that maybe we didn't get to. I think we got to nearly all of them in some general sense of the questions that I see here, but we're going to respond to all of them, and stay tuned for some more future webinars to come on a variety of topics. And I would just like to again thank you, Matt, with Plastridge, and thank you, Paula from Rosenbaum, And this was fun. We need to do it again. And Eric, if you are our technical Zoom moderator, are you on right now?
I am. Thank you, everyone. If you have any additional questions, please feel free to email us at info@castlegroup.com or follow us on LinkedIn, Instagram, Facebook, or even the castlegroup.com website for further updates and further webinars on these topics. So thank you, everyone, and please be safe and have a wonderful day.
Great. Thanks all.